All right, let's proceed. Good morning.
Good morning, Your Honor. Thank you. May it please the Court. My name is David Neosi, and I represent the Doe family and the American Humanist Association. Your Honors, this case presents a classic equal protection situation where an unpopular and wrongly vilified minority faces obvious official discrimination. The trial court failed to apply strict scrutiny despite constitutional and statutory enumeration requiring it. The errors in the trial court's analysis are actually quite numerous, and I'll address as many as time permits.
Could you start by saying what it is that the classification that the statute makes that you find to be unconstitutional?
Yes, certainly, Your Honor. The classification is, the statute requires that the state sponsor and teachers lead the Pledge of Allegiance to the flag every morning. So the question becomes, does the pledge itself classify? And I think the honest answer to that is that certainly it does. It affirms very unambiguously that the nation is one nation under God. Had the under God word not been in there, it would be one nation indivisible. But by inserting under God language into the flag, into the pledge, we have a pledge where children every morning are pledging their national unity and loyalty in an indoctrinational format in a way that validates religious God belief as truly patriotic and actually invalidates atheism as second-class citizenry at best, downright unpatriotic at worst.
Well, let me ask you this. We just opened this court session with the court cry, and the court officer said, what did the court officer say? She said,
God save the Commonwealth.
now, do you take offense at that? Or would your client say that is inappropriate language?
I would say that it can't be compared to a daily 13-year indoctrination where children every day when they go to school are being instilled with this idea that we are one nation under God. True patriots can stand up and say that.
But God Save the Commonwealth of Massachusetts is said across the state every day in every courthouse.
Certainly. It can be first of all, very few children would ever be exposed to that, but true, from time to time there are children in courtrooms. In that context, it can certainly be explained. If I'm in court with my child, I can say, oh, that's ceremonial. It is truly ceremonial. Nobody is trying to convey the idea that to come into a courtroom in this Commonwealth, one must be a God believer. But it's much different in a public school setting where every day for 13 years, thousands of times, and the pledge can only be understood to mean that by children. One of the arguments by the other side is that it's just an allusion to religious heritage or political philosophy or something like that. But, you know, ironically, any school child can tell you what one nation under God means. It means we're under God. The idea that school children are not going to understand it as a validation of God belief being connected to patriotism and atheism, you know, somewhat suspect. And we see the results.
And you would say the same thing regarding in God we trust on currency?
One could make that argument, although obviously that is not a state issue. That's a federal issue. But should the Commonwealth decide to pass a statute declaring that large in God we trust sign should be put up in every classroom, I think there would be a strong argument there that that would violate our Equal Rights Amendment, which very seriously takes equality.
Rights or Establishment Clause?
The Establishment Clause argument would be there as well, obviously, but this case is about the Equal Rights Amendment, the express enumeration of religion, creed as a suspect classification, entitling it to strict scrutiny. The ERA is serious equality. It's not...
Let me ask you, though, I mean, maybe I don't understand the facts here, but are you saying that the problem is that the children must listen to it being said every day, or that they are not able to say the pledge and be consistent with their conscience?
Both.
Is it the hearing of it, or the being required to speak it, or not being allowed to speak it?
It's actually both, because they are entitled, not just constitutionally, but under the statute where they're entitled to the advantages and privilege of public school education, they should be able to meaningfully participate in any patriotic exercise that's conducted in this Commonwealth in schools. So yes, they are denied meaningful participation in the exercise.
Are they not allowed, not merely to not participate at all for any reason or no reason, but are they not allowed to say the pledge but just omit that language?
Yes, but as they do that, they give the appearance of endorsing this daily indoctrination that defines patriotism according to God belief. So yes, an atheist child can get up and not say the under God words, but there they are endorsing, giving the appearance of unanimity on the idea that we're one nation under God. So it is the meaningful participation on one hand, but it's also the stigma that the idea that the class is promoting and propagating the idea that good patriots are God believers.
Has this issue been raised in other jurisdictions?
Certainly not in an ERA context, and in that context at all.
Not in the context of our Constitution. Certainly it was raised in the context of the federal Constitution.
One time it was raised as a
Circuit?
Yes, exactly. The FFRF case. But the FFRF case, any fair reading of it certainly sees that it was an Establishment Clause argument that was brought all the way. There was a 14th Amendment equal protection count thrown in, but for numerous reasons, it provides no guidance for this court with...
Well, he concluded that there was no equal protection violation.
In FFRF, yes. The FFRF the court bought into a couple arguments that would be serious errors for this court to make. For one, they make the equal application argument, which was rejected in Loving, and it was rejected in the same-sex marriage cases. In the same-sex marriage cases, the argument basically went, well, the marriage laws apply to everyone. Gays can get married. They just have to marry the opposite sex. No discrimination there, equal application. And in Loving versus Virginia, of course, it was, well, whites can't marry blacks, blacks can't marry whites, no discrimination there. The equal application is just, can promote and propagate invidious discrimination. Another thing the FFRF court did is that they bought into the voluntariness argument. The fact that the exercise is voluntary somehow makes it all right. I mean, the fact that atheist humanist children get to go to school every day to watch their class conduct an exercise led by the teacher that defines patriotism a certain way, that excludes them, is hardly a consolation. Voluntariness has no place in any...
What if the school made clear, and the school says that it is known to students that they don't need to participate, but what if at the beginning of the school year, which we're at, the principal over the loudspeaker says, we're about to recite the pledge. I want it to be clear to all students that no one need do it. They may choose not to do it because of religion. They may choose not to do it because they are not U.S. citizens and may be pledging their allegiance to a foreign land because they are visiting here. They may choose not to do it for a whole set of reasons, and that is your right as an American to not do it, and give the reasons why it is done, but make it clear that we all need to respect the choices of the students. Why would that not address the stigma argument and the classification argument?
That would still, that would be a baby step in the right direction, but it would basically be a statement of the law under Barnett already. The Barnett case is a free speech case, but the idea that voluntariness somehow plays into the classification argument just doesn't really fly. The exercise itself still discriminates. It defines patriotism a certain way. If the pledge said one nation without God, right? I mean, it would still it would still discriminate against believers. And, you know, the other side could say, well, we're not promoting atheism or disbelief. We're just alluding to our secular heritage and our godless constitution. But the reality is it's invidious. It certainly draws a line. It classifies between those who can say the pledge and thereby exhibit their patriotism and those who can't. The fact that there are numerous reasons for not wanting to say the pledge does not mean that it's all right for the state to have a patriotic exercise that does, in fact, discriminate against one of the important religious classes
Let's
in
go
this
along with
Commonwealth.
that, but does the Attorney General suggests that in order for it to be a cognizable classification, in order to be a classification at all, it has to have an effect on a person's legal rights or duties for equal protection purposes. And what impact does the pledge or the statute relating to the pledge have on any legal rights or obligations of any students or anyone here when they're not required to participate or not excluded from participating?
Again, mandatoriness is not what defines a legal right.
But there has to be some harm, doesn't it? Don't people have to be treated differently under equal protection analysis?
Oh, and atheists and agnostics are being treated equally.
In this context, I mean, treated differently because they can't say the pledge, I think.
Because they can't say the pledge, and because the entire class, the entire school is defining patriotism in a way that stigmatizes them. We wonder why there is so much anti-atheist sentiment in this country. You know, we have 535 congressmen and representatives. Not one of them is an open atheist. Barney Frank came out as gay 30 years ago. He only came out as an atheist after he left office. It really says something for the prejudice that is just permeating American society against atheists. Other countries, even third world countries, elect open atheists and agnostics to high office all the time. This country, we can't get one elected to Congress. Could it possibly be because we're drilling this into our children every single day for 13 years?
Counsel, if you prevail on this, what does this mean in other areas other than schools? Would you take the position that you also can't say the Pledge of Allegiance at public events, say a sports event, or at an assembly at a political event?
It certainly would be a weaker case, Your Honor, because some events can be understood as truly ceremonial. And I think when something is truly ceremonial, that one of the arguments here is that, you know, we're gonna wipe out any reference to God in public life. I think that's really an alarmist argument, and it doesn't take the seriousness of a daily pledge. We are indoctrinating children on a daily basis. And an occasional parade where they say the pledge, the argument just isn't there. There's a ceremony going on. You know, we sing songs and do things. I don't think anyone would take seriously that you know, there's a line being drawn and from good citizen and bad citizen. We know that we're a pluralistic society, that we want inclusion and we'll reflect different ideas at different times. But a daily, you know, every single day of the school year.
Are you asking for the right of non-theist children to say the pledge, but in a way that, are you asking for that? The right to say the pledge with everybody else? Except not under God. Nobody should say under God.
I think it's understood under Barnett now that an atheist child could get up and say the pledge without the under God
So
wording.
clarify for me. You don't want them to sit out, even if it's explained that it's not because of what your belief is or what you can do it for any reason, including your belief. So you're asking for the right to say it, or you're asking for it to be changed so that nobody says it?
We are asking for a declaration that the current practice be ruled unconstitutional because it violates the Equal Rights Amendment, which expressly forbids religious discrimination. That would be the starting point.
The current practice being including under God, or the current practice?
You mean the statute? The statute's
The
requirement?
statute requiring
Yes,
it.
and the current requirement of saying the under God version. Now, where the court goes from there are different remedies possible. Maybe just tell the schools to start from scratch and And if they're going to have a daily patriotic exercise, just make it one that is inclusive. And there are a number of different ways. We refer to them in our brief. We could look at heroes and events of American history. We could do all different things. There's no limit to the ways we could promote patriotism
Could
and
a
national
school
loyalty and
promote-
unity.
Could schools, just for a moment, promote patriotism by all deciding, after invalidating the statute, that they will say it every day with as is, and that they will begin the day by recognizing that they're going to do it and that people may opt out, and those children who wish to say it without under God may do that. Is that okay?
Well, opting out is hardly a solution.
They don't have to opt out. They may also opt in, and they may decide to say the pledge, excising the language with which they do not agree.
Yes,
After
but
being explained to all students that they all may do that.
But that would be giving the appearance of endorsing the basic idea of the official pledge that everyone is saying, which is invidious to atheist humanists.
And is it your view that we need to essentially abolish the pledge or simply abolish the words under God in the pledge?
I think certainly the plaintiffs would prefer that we go back to the original pledge that's a one nation indivisible. But if that is not an option, then no, we just find another way to instill patriotism in children.
And if we do that, would we not then next year have a group representing aliens who say we are the children of visiting business persons from foreign countries and it's not appropriate for our children to be in a classroom where they're being asked to pledge allegiance to a flag that is not their nationality?
Well, not quite, Your Honor, because the argument here is that they are defining patriotism in terms that exclude us. We're not expecting aliens to be patriotic. It's not an expectation of them. But my child and other children in this Commonwealth are citizens, and there is kind of an expectation that we be patriotic. So aliens really would be an apples and oranges comparison.
Counsel, we'll have to leave it there. Thank you.
Thank you very much.
May it please the court. Jeffrey Bach on behalf of the Acton-Boxborough School District and the other school defendants. Your Honors, in 1995, in a unanimous decision by Chief Justice Liakos, this court ruled, quote, parents have no right to tailor public school programs to meet their individual religious and moral preferences. Quite frankly, Your Honor, this is a case that should have been raised, if at all, under an establishment and free exercise clause and should have been rejected on that basis.
Under the state constitution?
If it had been argued, Your Honor, and it was not, we would be here arguing it on that basis. And I think with all due respect to the plaintiff's skill as an attorney, you would be, rejecting it. And that's the reason that they skillfully cherry-picked out the Equal Rights Amendment and tried to make an equal protection argument. There's a reason that the First Circuit, in dealing with effectively the exact same, as applied Pledge of Allegiance procedure up in New Hampshire, dispensed with an equal protection argument in one long paragraph. I believe it was one. It might have been two. And it's the reason because sometimes arguments truly do not require a lengthy response. It's the reason that this court sometimes has short opinions or rescript opinions and not long ones.
You don't see this as a classification implicating creed under the Equal Rights Amendment?
Absolutely not, Your Honor. There are many, many reasons that a person could choose not to, say, the pledge. Justice Gantz went through them, and I would add to that because of the fact I've raised two teenagers. They might simply, opt out just to be,
Yeah, but it's hard for a 6-year-old. It's hard for a 6-year-old to opt out, isn't it?
Well, not necessarily, Your Honor. There isn't a classification here. Certainly not, on the face of the statute. Certainly not in the implication of the statute. Under God is mentioned in the middle of the Pledge of Allegiance.
Suppose it was instead one nation led by white men.
Well, that would certainly implicate certain protections, absolutely, Your Honor. I'm not quite sure since I haven't thought I think historically, you have to understand the under God reference.
Historically, that would have been accurate, wouldn't it?
Historically, it would have been, Your Honor, and absolutely not true now. And the fact is that the classification here is that they're alleging is, religion. There is no religion bias in the statute. The only mention of religion is in the pledge itself, where it does say under God. It is not a prayer. It is not an invocation. It is something that is mentioned.
Not an
in
affirmation?
It's not an affirmation. It's a statement. It's a statement of our political. It's our statement of our political philosophy. It's the founding thing on which our country was founded. That our rights did not come from the king or the czar or the queen. They come from something higher, or they are innate. It's the argument upon which slavery was abolished. That we truly believe that all men have these rights. It's a political philosophy, and my brother argues this far more persuasively in his brief. But it's a long-standing political philosophy. It's the political philosophy that was espoused by Lincoln in the Gettysburg Address. It's the political philosophy that is contained in our Declaration of Independence. It is inherently a political philosophy. And as long as we're talking about the use of the word, God, with all due respect, one should actually look at the U.S. Constitution and the Massachusetts Constitution. The Massachusetts Constitution mentions God throughout. And in fact, in it specifically says that it is the right and the duty, I believe it says, of all citizens to praise the supreme being. In contrast, the U.S. Constitution never mentions the word God, not once. And so for this court to say that the Massachusetts Constitution, that has to be read as an entirety under long-standing precedent, should be interpreted differently than the federal Constitution, it's simply not, I believe, accurate, particularly when taken into account that this court in the Finch case said that the Equal Rights Amendment, except in the context of gender, did not change this court's adherence to federal equal protection standards. Federal equal protection standards do not protect against the alleged discrimination here. And so with all due respect, I don't believe that just because it uses the word under God, that it comes underneath the Equal Rights Amendment and underneath protection under the Massachusetts Constitution, where it does not come under protection under the federal Constitution.
Now, you agree that it would be unconstitutional if students were denied the opportunity to opt out.
Absolutely, under Barnett, no question about that.
Is there any obligation of a school to inform its students that they have that duty? Since unless a 6-year-old or 8-year-old has read Barnett, how would they know they have that opportunity?
Well, I can tell you in this case, Your Honor, it was stipulated and agreed to that it was done on a purely voluntary basis.
Well, you
in my
say that,
school
but I
district,
mean,
the students are told that. So I can only tell you on this fact.
Superintendent Mills' affidavit, and he says it is voluntary, but he doesn't say that students are told it is voluntary, and he doesn't say that students are told that they may abstain from either all or even part of the pledge. They have the opportunity to say part of the pledge, but not all of the pledge if they think that doing so would in some fashion compromise their belief. I didn't see anywhere in the record that students are informed of that in Acton-Boxborough, are they?
I don't know if it's necessarily stated in that part of the record. However, the plaintiff students, I believe, all filed affidavits, and their affidavits went through that they understood that it was voluntary.
They knew, I understand, but I think given them and their parents' beliefs, they are probably a bit more educated as to their rights than the average student. Is there not an obligation of the school to inform its students of what they say are their rights, which is the right to opt out in either in part or in toto?
I can only say that my understanding is that my clients inform the students that it's voluntary, and the students understand that it's voluntary. I can't speak for every single school district in the Commonwealth, and that there was not one single claim in this case that my clients coerced, intimidated, forced, or pressured the Doe children to do the pledge. So that on this factual record, that absolutely does not exist. Is there a school district somewhere that might do that? Hypothetically, yes. Not here. Although I add that the plaintiffs did not file evidence of one single student anywhere in the Commonwealth, anywhere since 1954, claiming to be intimidated anywhere in this Commonwealth. So that we're not dealing with widespread intimidation or forcing.
And do I take from what you're saying that you agree that if there was affirmative stigmatization of humanists, that would pose a classification problem that would make this truly a case of equal protection?
No, Your Honor.
Okay, so,
And as brief
so the
then as
are the stigmas I mean, well, let me ask you this. If a teacher were to say, all humanists, I'm going to now provide the pledge, but I understand that humanists don't believe in God, so they should not say the pledge, would that pose a problem of equal protection?
I'm not sure if it would pose a problem for equal protection. It might well pose a free exercise or an establishment, and that's the problem here. They keep, trying to bring in other rights and to try and bring that in. Equal protection stigma law, I believe, is extensively briefed by the Attorney General and by, my brother in their briefs, and so I respectfully refer you to that. But my understanding is that they do not have a valid stigmatization, claim here, and on that basis, I don't believe that they have that. Your Honors, one final thing. My brother invoked Loving and invoked Goodrich and basically said that the Pledge of Allegiance law is in violation of those. Those are very, 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 very strong words. And his briefs also cite to Brown versus Board. In all those cases, the laws as applied has had very explicit classifications that discriminated and denied essential rights. Absolutely not, true here. And I think that the voluntariness of this statute, which is absolutely undisputed.
But voluntariness has nothing to do with equal protection analysis, does it?
Absolutely does, Your Honor, even if Your Honor takes it all the way through. And I do not accept that we ought to be under rational protection or strict, scrutiny. I think it ought to be just flat out rejected. But even if we go all the way down the end of the road and we go to strict, scrutiny, the question is there a legitimate purpose, and is it done in the least, intrusive fashion possible? A voluntary provision is about as unintrusive as you can imagine. I mean, imagine any law standing up here, a person saying it's illegal, however, it's completely voluntary. And you'd say, well, if it's voluntary, how can it be a violation of equal protection? The voluntariness is good.
What about the sports cases? You don't have to participate in sports, but you can't, the fact that it's voluntary doesn't preclude you from looking at the classification.
Absolutely, and in the sports cases, that is the Attorney General versus the MIA case, it said that you cannot deny a person of the right to play on a team because of the fact they are male or female.
But they don't have to play on a team at all.
That's correct, but in that case, there was a classification, and so the court didn't even have to reach. I mean, in that case, the voluntary. Let me start again. First of all, those cases involve the classification. Our case does not, I would say, with all due respect.
Let's assume that there's a classification here. What does voluntariness have to do with the matter?
Because it's the least, intrusive fashion possible.
Time is up.
Thank you, Your Honor.
Thank you.
May it please the court, Eric Rossbach for defendants, interveners, appellees. If I could pick up on a question from Justice Lenk early on. The question is, what is a classification, and what is the classification here? And I think if you look at this court's cases, they teach that there's really sort of two main factors that would constitute a classification. And understandably, a lot of equal protection cases don't even talk about this issue in depth because their classification is obvious. But I think there's two factors. One is a sorting into groups. So that if you look for the word group in your cases, you can see that there's always a sorting into two different groups that occurs. And then the second thing is that there's some kind of tangible consequences that result from that sorting. So, for example, Justice Lenk was referring to the Commonwealth's brief, and it talks about cognizable legal rights or duties. And I think that that's really the tangible consequences that come from the classification. And here, there's neither of those factors is present. There's no sorting into groups by the language of the pledge.
Well, it doesn't have to be on its face, does it, in order to be an equal protection problem?
No, so if it were
implicit
via a policy or something like that, but that's certainly.
You could look at this and say, well, there are going to be people who think that the nation is under God and people who don't think it's under God, but they can still both be Americans, and so it does sort into two groups: the real Americans who accept that this is a nation under God, and the non-theists or who are not accepting of that proposition.
I think it depends, though, who the subject of that sentence is. That is, if the verb is sorting and the object is groups, is it the government doing the sorting, or is it a kind of self-sorting? That is it the individuals that are deciding that they're having a problem with it? Because I think that here the government is not sorting people by using the words under God.
Well, would the government be sorting if they used the words led by white men?
I don't think that would constitute a classification under equal protection jurisprudence. I think it would violate a host of other problems, and Massachusetts would probably get in trouble with the Federal Civil Rights Division. But I don't think that it would be strictly speaking, a classification. It would also affect a fundamental right, which is, of course, the other way that you can get to strict scrutiny under the Equal Rights Amendment or under federal equal protection jurisprudence. But, of course, they've waived that argument here. They haven't made it. And they didn't make it on purpose because they don't want to get into the issue of free exercise or Establishment Clause type rights. They've specifically tailored their lawsuit to only focus on the Equal Rights Amendment.
Of course, our state law, case law, is not well developed on fundamental rights under equal protection in any event.
You would know that better than I would. I think that fundamental rights jurisprudence is not one that's a model of clarity at either level. So I think that, as I was saying, there's neither of those factors, sorting into groups by the statute, nor the tangible consequences are present. And one other thing to keep in mind here is that we're talking about
But isn't there a sort of a self-sorting process that's taking place here? You're asking somebody who is not God-fearing to declare that they're not God-fearing and not participate in a Pledge of Allegiance.
Well,
I mean,
how would anyone know that whether they were a Jehovah's Witness or not?
Does
or
it
an
matter
atheist?
that they were a Jehovah's Witness? It's simply somebody who, for religious reasons, does not want to declare that they are God-fearing.
But what?
Well, the Jehovah's Witnesses are God-fearing, but they don't. But they sit down during the pledge, and they will be, even if the plaintiffs were to get the line edit that they're looking for from this court, they would still be sitting down because they believe that.
Okay, so that's a different classification. How about the classification of atheists, people who simply don't want to declare themselves or align themselves with God-fearing people?
I guess what I'm trying to say is that the government is not doing any sorting there, and I may not be following the question, but I think that there's no government sorting going on in the pledge. The pledge doesn't say atheists shall not be allowed to say the pledge, and believers in a monotheistic God shall be able to say it. It just includes the words "one nation under God."
But a non-believer would have to say that, act contrary to their own beliefs.
So first of all, I don't think that I do think that there's a misprision of fact here. That is that I don't believe that the pledge is making a religious claim about God or the existence of God or any number of
No, it's making a claim
theological.
about the country, that the country is a nation under God.
Right, and I guess what
You're pledging allegiance to that aspect.
you're pledging allegiance to the flag, and as we put forth in our brief, we actually believe that the term under God is a legal term of art that goes all the way back to the 1200s that talks about the limitation on the government's ability to take away rights. That is, that we have a limited government. So I actually think that an atheist may be offended by it, but I actually don't think they should be, because I think it's a statement of political philosophy as opposed to a religious claim.
And that's, I saw that, and it's interesting that you view essentially the term under God as essentially meaning a matter of natural law from whence our rights derive. But do you think many 8 to 10-year-olds understand that when they say it?
My guess is that they think of the pledge as sort of one very long word. I'm not sure that there's
If we declare it to be meaningless, then we at some level trivialize. I mean, it is a pledge of allegiance to a country. We'd like to think that liberty and justice for all means something. We hope that folks take it seriously. So, I mean, is it fair to say that, under God does not truly mean under a deity. It means essentially our source of rights derives from natural law and cannot be taken away by the state.
I really do think that, and I think that's what the Ninth Circuit said in the Rio Linda case. I mean, if you read that case, they adopt that view pretty clearly. And, you know, it's also in the pediment of the Harvard Law School library. I don't think that Harvard Law School is necessarily attempting to, you know, sort of proclaim a religious statement by that. I think it's making a statement about the importance of having a government of laws, not of men.
And we are to assume that our school children understand that to the same extent Harvard Law students understand
I don't think so,
it?
but I'm not sure that the standard about school curricula is that they understand it right from the beginning, or unfortunately sometimes they don't understand it even after they get a high school diploma. But I think that there's a real issue. If you make the standard, what does an average 6-year-old understand? There's going to be a lot of lawsuits under equal protection because they're not going to understand a lot of things. There has to be some reliance upon parents and others to explain this is what we're doing.
Counsel, I'll give you another minute or so to wrap it up if you'd like, or you can stop.
No, I think I've, unless there's anything else.
All right, thank you very much.
Thank you.